Andrew Lee Lakey, please come forward. Jefferson County Court, number 2 is back in session with the announcement docket. We have 1, 2, 3, 4, 5 cases. All 5 cases are styled of State of Texas versus Andrew Lee Lakey. Mr. Lakey, is that your full name?
Yes, sir.
How you doing, Mr. Lakey?
Good, how are you?
I'm doing fine, thanks for asking. Mr. Lakey, you representing your cases by your attorney, Brian Matuska. Attorney Matuska, how are you doing?
Good afternoon.
Good afternoon. And the state is representing this case in these cases by Attorney Haley Simmons. Attorney Simmons, again, how are you doing?
I'm great, Judge. How are you?
I'm doing fine. Now, Mr. Matuska, what is your announcement in Mr. Lakey's cases?
Your Honor, we've been waiting for the felony court. My understanding is today they gave Mr. Lakey a reset on his felony cases, correct? So we're asking for another announcement docket setting so that we could try to work those out together.
Okay, now, so we have 3 different offense dates for these 5 misdemeanors. 2 misdemeanors, first 2 misdemeanors occurred on one day, and then the second 2 misdemeanors occurred on a different date, and then the last misdemeanor occurred on a different date. So I would assume that his felony case occurred on one of the dates that either 1 or 2 of these misdemeanors occurred on. Was that correct?
Your Honor, it's my understanding that he has multiple felonies all on different offense dates. I'm confirming right now, but as it stands, he does have 2 felonies with 2 separate offense dates.
Okay, now, what's the date on one of the felonies?
11/16,
but that's the day after 24.
Oh, that's after 11/15.
and then 12/13/2023, Your Honor, for the other.
12/13. Oh, that's before the 12/13, what year?
2023.
That's before the 12/31 of 2023. Okay, so we could set these things. I'm not gonna keep them together because we keeping them together with the felonies, then it's just prolonging the disposition of these cases. Because those felony cases, I guess, been out there for a while.
Your Honor, we could be ready for trial on whichever one you want to proceed on.
Well, we could set all of them. I mean, y'all, you want to set every one of them for trial, or just let me know how y'all want to proceed on.
Or whichever one y'all want to try first. So.
We would try the oldest first as far as misdemeanor goes, Your Honor. If
Okay.
he wants to set all of them for trial.
Okay. Okay, let's give us a trial date. What is that date? May 5th. That's, well, let me see. Make sure that's not on another day, because we got another one also. That we're trying to get to on
I think we would, and I think we go.
where is this? That's, we might be able to, well, we have another older case. You have another
We might
trial
put it
date?
on that then. What's that, Your Honor?
I was asking her for another trial date because I think Macy has Wiley on May 5th. And that's
That's the
older.
2018 case, Your Honor. That case will be resolved on that day. Regardless, that case will be resolved. I don't think
When you
it's
say
been
resolved, you saying you don't think it's gonna be a trial?
It shouldn't be, Your Honor. There is a issue as to the burden that the state is
Okay.
confronting.
So let's put this on May 5th too then.
Your Honor, I think there's a very likely chance there'll be a federal trial that will begin then and probably will last until the end of the month.
Okay, give us another trial date.
So what would either go would be the criminal mischief or the possession that occurred on 3/12/2022.
Not the month.
And those are the same.
Yeah,
You have to be June 2nd.
June 2nd. Okay, so we're gonna reset these cases, trial June 2nd.
Do we know if we have a court reporter on that day? Because I'm sitting second.
Now, did we have,
Okay, because I'll be in drug court.
okay, so we need to, well, let's do this here. Let's hold off and giving them a date right now. we'll get you one where we'll have one, date certain, so this case can go to trial.
Sure.
Okay. Okay. Stay in contact with your attorney and your boss. You're free to go. And you have a blessed day.
Yes, sir.
Okay.
Just call us.
Yeah, the week of June 2nd, I'll
You may be seated. Jefferson County Court at Law number 2 is back in session. The court is in session and calls number M324-280, case style of state of Texas versus Angel Luis Cruz Bruno. Let the record reflect that Mr. Bruno is present in court with his attorney, Attorney John West. Let the record also reflect that the state is present with Assistant District Attorneys, Attorney Haley Simmons and Attorney Shane Hilton. State, are you ready?
Thanks, Your Honor.
Defense, are you ready?
Ready, Your Honor.
And let the record reflect that the jury is now present and seated in the courtroom. Ms. Simmons, you may proceed.
At this time, Your Honor, the state calls blood analyst Mimling Altamirano.
Mimling Altamirano. Altamirano, would you please come forward? You raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you may put your hand down. You can take the witness stand. Ms. Simmons, you may proceed.
Thank you, Your Honor. Good afternoon.
Good afternoon.
Could you go ahead and state your name for the record, please?
Yes, my name is Mimling Altamirano.
Okay, and can you explain to the jury your occupation?
I am a forensic scientist for the Jefferson County Regional Crime Lab.
And how long have you been with the crime lab?
Approximately 18 years.
Can you tell the jury your educational background?
I have a bachelor's degrees in biology.
Specific training with blood alcohol toxicology?
Yes, so I've had extensive internal training, external training by different organizations. In addition to that, I've been competency tested. I get proficient yearly, and I'm licensed by the state of Texas.
Are you an expert in blood toxicology?
Yes,
Have you testified in this area before
yes,
as an expert
yes,
in this county?
yes.
Many times or few?
I would say a few times.
And are you licensed by the Texas Forensic Science Commission?
I am,
Okay. Are you licensed as a blood alcohol toxicologist?
I am.
Okay. How did you become licensed?
You have to go through extensive training. You have to maintain certain educational requirements and yearly training. In addition to that, you have to be under an accredited laboratory.
Can you tell the jury when you became licensed?
November 2018,
Were you licensed on April 18th, 2019?
I was.
How often are you relicensed?
Every 2 years.
Your Honor, may I approach?
Yes, you may.
Okay, I am showing you what has been marked State's Exhibit 3. And looking at this, do you recognize it?
I do.
Okay, and what is it?
This is a blood kit, ma'am.
Absolutely.
Thank you. So this is a blood kit that has our unique lab number, our exhibit, and my initials, in addition to our crime lab seal.
You said your initials as well.
Yes, so MAA are my initials.
I'm going to open this up. I'm going to show you what's been marked as State's Exhibit 3A and 3B. Are you familiar with these items?
Yes,
Okay, can you identify these?
I can identify the blood tubes inside.
Go ahead. You want to open those up for the jury? And can you tell the jury while you're doing this, how you're able to identify them?
So I'm able to identify them in the same method as the box. So for this one is lab number. I put the letter A for this vial and then my initials. And so this will be test tube A.
And just to confirm, is this the test that you, or the test tube A that you had tested?
Yes. And then this is going to be the same thing, lab number. This will be test tube B and my initials.
Can you tell the jury what condition the blood was in when you received it?
It was in a sealed condition.
Okay. Did the blood show any signs of spoilage?
No.
Okay, and if there would have been signs of spoilage, would you have been able to test the blood?
No,
Okay. Is this in the same condition?
yes,
Has it been tampered with at any point in time?
it doesn't appear to be.
Okay, I'm gonna tender this to defense for inspection, Your Honor.
Move for admission.
I am.
Your Honor, we would object to the mission of the blood evidence. Specifically, my objection is going to come under Texas Transportation Code 724-017. That lays out the qualification of the person taking the blood. In this case, we didn't have the person taking the blood testify as to the procedure or their qualifications. The officer did testify yesterday that he observed the blood being taken, so that could be evidence of that. However, there's are 5 people that are qualified under the code to take blood: a physician, a qualified technician, a registered professional nurse, a licensed vocational nurse, or a licensed or certified emergency medical technician. There was no evidence of what this individual was. The officer did say he believed she was RN, but he said he didn't know her training, her certification, her skills, didn't even know her before or after. So there was no testimony or proof, evidence that she was one of these 5 qualified people to take the blood. And if the person taking the blood is not one of these 5 qualified people, it's inadmissible. So we would object to the admission of this blood evidence.
State.
Your Honor, if I may, the proper predicate has been laid for purposes of admissibility. If at any point in time the defense counsel should be attacking the veracity of the blood, he can take that up with the expert on cross. Furthermore, I want to add that the defense objection is to the chain of custody, which the state shows the beginning and the end of the chain of custody. And if there is any gaps in between, that goes to the weight of the evidence and not the admissibility. Both Officer Boudreaux and now expert Memling Altamirano have testified as to the fact there has been no tampering whatsoever. The state can provide you case law at which point in time does state that as long as we show the beginning and the end chain of custody, it should be admissible. And that is referencing exhibit 3A and B.
Yeah, my response to that is that I'm not attacking the chain of custody. They clearly established the blood went from the person taking the blood to the officer who secured it, who did that. That's not an issue, which sometimes is an issue in cases, but it's not in this court because the state did a very good job of establishing that. My attack is specifically transportation code. It says you have to be one of these 5 listed individuals in order to take blood that can be tested in a case like this. Okay, it's specifically in transportation code, and it's the code that says taking a blood specimen. My objection to this blood is that the person that took this blood, we don't know that she's one of these 5 things. We have no proof or evidence that she is one of these 5 qualifications: a physician, a qualified technician, a registered professional nurse, a licensed vocational nurse, or a licensed or certified emergency medical technician. We don't know her qualifications. We don't have that evidence. It's not like the officer said, yes, I know her. She's testified in court before. She's taken blood before. She's an RN at the hospital. I know her from experience. We don't have it. The officer, I asked him questions specifically. That's the reason I went and asked those questions is like, do you know this person? No. Have you ever worked with this person? No. Do you know if she's an RN? I think she was. I think that's the closest he got to is that he believed she was, but he couldn't verify that she was an RN. She could have, we don't know what she was. I'm not going to assume that she is or isn't because I don't know. And in a court, you have to establish that. The state has to establish those things.
Your Honor, if I may, on cross-examination, he does in fact ask Officer Stephen Boudreaux whether or not she was an RN, and he did answer yes in the affirmative.
Yes, and I asked him, how do you know that? And he said, well, I believe she is. He didn't know anything about her. And that's like, would you even know her if she was in the courtroom today? And he's like, no. So he clearly said he didn't know anything about her. He just says he believes she's an RN because she was in the hospital. And she's the one that took the blood. But there was no proof of that. So I would object to this evidence based on that.
No, man. Ladies and gentlemen, jury, gonna ask that you step outside for a few minutes. You may be seated. Jefferson County Court at law number 2 is back in session. The court is in session and calls number M324280. Case is filed in the state of Texas versus Angel Luis Cruz Bruno. Let the record reflect that Mr. Cruz Bruno is present in court with his attorney, Attorney John West. State is present with Assistant Criminal District Attorneys, Attorney Haley Simmons, and Attorney Shane Hilton. Let the record also reflect that the jury is now present and seated in the courtroom. State, are you ready? Defense, are you ready?
That's right, Your Honor.
Okay, Ms. Simmons, you may proceed, and just for the record, the court overruled the objection.
Just to confirm, states exhibit 3A and 3B have been invented.
Yes.
Hello again, Emily. Okay. Can you go ahead and start by telling the jury where it is you store the blood at your lab?
So once the blood is submitted to our laboratory, we store them in a refrigerator.
And referencing this blood that you had tested, what did you do when you received the blood?
We make sure that everything's sealed, that the information on the blood kit is the same as the submission form. Once it gets stored in the refrigerator, and once I'm ready to analyze it, I'll go ahead and assign it to myself and then move forward.
Did you analyze the contents of the blood tube to determine its alcohol content?
Yes, I do.
And do you keep a blood alcohol quantitation log for that?
I do.
Can you explain to the jury what that is?
Sure. So the quantitation log, basically at the very top, you'll have all the reagents that I use, the lot numbers for those reagents. Then you'll have a set of controls. And then you have each case that I performed in a batch. Normally I perform 20 cases per batch. Then you have another set of controls in the middle of that batch, and then another set of controls at the end of the batch. So there's controls throughout the whole process.
Is the control to be in a specific range?
It's placed in a specific order, yes.
Is the result as well?
Ma'am,
Is the result kept in a specific range as well?
yes.
And what were the results in this actual case
May I
within
provide-
range? Absolutely, yes, ma'am.
I just- So the results for this particular blood tube was 0.125 plus or minus 0.008.
And is that within the allowable range?
Yes,
Okay. Was the lab or testing or conducted at the time of this testing, was it an accredited lab?
yes, it was.
Okay. What scientific process do you use when testing the blood and determining the alcohol content?
So we use an instrumentation called headspace GCFID. The GC stands for gas chromatography and the FID stands for flame ionization detectors. So basically that's a method in which if a volatile is present in a mixture, it will separate the volatile out.
Were the instruments at the lab working properly at the time of this testing?
Yes, they were.
Is there a method that your lab uses in determining or the calibration for the instruments?
So prior to any type of analysis, we calibrate the instrument and it's basically to establish that the instrumentation is working properly. The calibration curve is made of 6 known ethanol concentrations. So they analyze them, they get plotted in a linear graph, and after that, we use that as reference to determine the concentration of unknown samples.
Did you follow proper protocol when testing this blood at the lab?
Yes,
Okay. Were the results? Did you receive results for this blood?
yes.
Okay. What were the results?
So the results were 0.125 plus or minus 0.008.
Okay. And did you draft a report of those results?
I did.
Your Honor, may I approach?
Yes, you may.
I'm handing you what's been marked as exhibit number 4. Is this a report that you had drafted?
Yes,
Has it been altered in any way?
it doesn't appear to be so.
Your Honor, I'm going to tender this to defense for inspection.
Okay.
Your Honor, the only objection I make is related to the objection I made for the prior exhibit, but otherwise,
Okay. So State's Exhibit 4 is that right?
And based on your training experience and the results of this blood test here, do you have an opinion as to whether the defendant was intoxicated?
Based on my training and opinion, I believe that concentration is to be intoxicated.
I pass the witness, Your Honor.
Good afternoon.
Good afternoon.
I just have a few questions, should be very quick. Can the instruments that's used to measure the VAC, I'm not gonna get technical names, but it's possible for them to malfunction and give wrong readings, right?
It's possible.
Okay. And other things involved, despite the machine can cause false readings. Is that correct? Is there
So-
something, can other things cause false? That echo right there, it bothers me. Can other things cause false readings?
I would say that not with this particular instrumentation, simply because that instrumentation is used solely for ethanol. So there are no other compounds or other types of drugs that get analyzed in that instrument. And in addition to that, there are several controls that get run through before.
Well, I'm not talking about actually the machine or the instruments there, but is there anything about when they take the blood that could cause the blood to come off, what's it called? I don't know if it's tampered with, can other things get into the blood that could cause the readings to be different?
The blood, depending on, the blood could get bacteria or other organisms that could degrade it.
Okay. And maybe if the person taking the blood used alcohol swab, could that affect the readings?
So actually, there's been a study in which, so I'm gonna say no, but there's been a study in which they purposely use alcohol swabs in samples taken, and they never were detected in the blood.
And just for the record though, just to clear up, you didn't take the blood, did you?
No, I did
Okay.
not.
You weren't around when the blood was taken.
No, I was not.
You've never even met my client or seen my client, have you?
No.
This is the first time you've probably seen him ever.
Yes,
Okay, unless maybe out just socially, you might not, but my point is, you don't know how the blood was taken or any of the procedures followed.
I don't know.
Okay, all you know is they gave this to you and told you to test, and that's what you did, right?
That's correct.
Briefly, Your Honor.
Okay,
Just to confirm, whenever you receive the blood kit and the blood tubes, is there identifying marks would be defendant's information such as name, date of birth?
Yes, so, wait a second. Yes, so, whenever we receive the blood tubes, we look at the name on the blood tubes and match them back to the submission form to ensure that it's for the person that they're saying this for.
So there is a method in process or in place with the lab to confirm who is or whose blood you're testing.
Yes, it has to match the submission form.
No further questions for this witness, Your Honor.
okay, Mr. West.
No, no.
Okay, may this witness be excused?
Yes, Your Honor.
Okay. Ms. Mingling, you are excused. You may step down and you have a blessed day.
Yes, well, thank you.
You're welcome. Thank you. May I call your next witness.
Take rest.
State your rest. Mr. West,
1 second.
Yes. Okay, ladies and gentlemen of the jury, will you please stand and exit the courtroom? Is anybody in the, oh, yes.
Have them exit, or we can exit.
You need to, hold on a minute. Okay, court will be in recess. Let's see, hold on a minute. Hold on, where's the, hold on, wait up. I'm looking for my, oh, here it is. Okay. When the jury come in, I'm gonna ask everyone to stand. Yes, would you please bring the jury in? Okay. Everyone may be seated. County Court at Law number 2 is back in session. The court is in session in clause number M324280. Case is style of the state of Texas versus Angel Luis Cruz Bruno. Mr. Cruz Bruno is president in court with his attorney, Attorney John West. State is president with Assistant District Attorneys, Attorney Haley Simmons, and Attorney Shane Hilton. Let the record also reflect that the jury is now present and seated in the courtroom. And Ms. Simmons, you have rested, is that correct?
Yes, Your Honor.
And Mr. West?
The defense restaurant.
Okay, so the defense rests. So, ladies and gentlemen of the jury, both the state and the defense have rested their cases. And so the court has prepared a charge. And so at this time, the court will read to you the court's charge. Now, once the court reads you the charge, we'll have closing arguments from the attorneys. And then after the closing arguments, then the case will be put in the hand of the jury. Okay. Members of the jury, the defendant, Angel Luis Cruz Bruno, stands charged by information with the offense of being intoxicated while driving or operating a motor vehicle in a public place. The offense is alleged to have occurred on or about the 18th day of April, 2019 in Jefferson County, Texas. The defendant has entered a plea of not guilty. Our law provides that a person commits an offense if the person is intoxicated while driving or operating a motor vehicle in a public place. A person is deemed to be intoxicated within the meaning of the law when such person does not have the normal use of physical or mental faculties by reason of the introduction of alcohol, a controlled substance, a drug, a dangerous drug, or a combination of at least two of these substances, or any other substance into the body, or to have an alcohol concentration of 0.08 or more. A public place means any place to which the public or a substantial group of the public has access and includes, but is not limited to, streets, highways, and the common areas of schools, hospitals, apartment houses, office buildings, transport facilities, and shops. Now, if you find from the evidence beyond a reasonable doubt that on or about the 18th day of April, 2019, in Jefferson County, Texas, the defendant, Angel Luis Cruz Bruno, was intoxicated and while so intoxicated did drive or operate a motor vehicle in a public place in Jefferson County, Texas, then you will find the defendant guilty. Unless you so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty. General instructions. All persons are presumed to be innocent. No person may be convicted of an offense unless such element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, indicted for, or otherwise charged with the offense gives rise to no inference of guilt at the trial. The law does not require a defendant to prove innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You have a right to consider all the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. You cannot question the bailiff concerning the testimony or the law, nor should you discuss the case in her presence. If any question develops during your deliberation, it must be reduced to writing, signed by your foreperson, and given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by the law. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. Any physical exhibits admitted into evidence will be furnished to you by the bailiff upon your request. You must not consider facts that have not been introduced into evidence or legal principles not contained in this charge. It is improper for you to discuss or consider anything which you know or have learned outside of the testimony presented to you and the law contained in this charge. If you should discover that you have any outside information, you should not mention this information to any other juror, nor consider it yourself in arriving at a verdict. Our law provides that a defendant may testify on their own behalf if he elects to do so. This, however, is a privilege accorded a defendant, and in the event he elects not to testify, that fact cannot be taken as circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against the defendant. You are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, or your deliberate violation of this charge could subject you to being held in contempt of court. After the attorneys present their arguments, you will retire, select a foreperson, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during the evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case. Now, the last page is the verdict page. You notice that there are two sections. The top section states, We, the jury, find the defendant not guilty as charged in the information of driving while intoxicated in a public place. If that is your verdict, then your foreperson will sign on the top line. Or the bottom verdict says, we, the jury, find the defendant guilty as charged in the information of driving while intoxicated in a public place. And if that is your verdict, your foreperson will sign on the bottom line. Does everyone understand? Okay. State, are you ready?
Yes, Your Honor, at this time, the state would like to reserve the right to close and waive the right to open.
Defense, are you ready?
There you go.
Now, Mr. West and Ms. Simmons, is 15 or 20 minutes enough? How much time do you need? Okay, I said 20 minutes.
That's fine. I should be probably quicker than that. I would
Okay.
think.
And I'll be keeping time.
You'll hold me to that. All right.
Okay, Mr. West, you may proceed.
Thank you, Your Honor. Good afternoon, everyone. And we just talked about being kind of quick here, because this was, despite us being here for day 3, this was okay. And I say that meaning that it was very succinct evidence. It was just, here's the evidence, let's move on, okay? We try not to put too much into that. Now, I will start off with one thing. One witness you did not hear from today, and we talked about this before hours in the minute. You did not hear his side of this, okay? And the jury instruction when we talk about before hours is that you cannot hold that against him, okay? And the question becomes, well, what do you even possibly say about this? Not much, because you've seen on video. Everything he needs to say, you've already heard, okay? So let's look at this case, because like Miss Simmons said in the beginning yesterday, there are 7 things she has to prove. Okay, let's talk about it. Okay, has to prove April 18th, 2019. No doubt about it. We know this one happened. Okay, nobody disputes that. The accident happened in Jefferson County, Texas. We know where it happened. It happened with us. The defendant, Angel Lee Cruz Bruno, that was him. You even saw him on the video. Okay, so we know it was him out there. Was intoxicated, and while also intoxicated, we're gonna circle back to that one. Did drive or operate a motor vehicle. You saw the car pass by. You saw that. Okay, you know that he was the only person in the car. He was driving in a public place in Jefferson County, Texas. Again, you saw where he got pulled over. He was driving on the roads in Jefferson County, Texas. So, again, it's one of the things that we're not going to talk about those other 6 things. We're going to talk about intoxicated. That's what this case is about. You could get that Monday. All the things that I talked about, all the things Ms. Simmons talked about, you do this for, okay? So, and again, we talked about these in voir dire about what intoxicated is, and that's on page 1. Judge has it there, okay? And Ms. Simmons did a great job. I'll talk to you about it on Monday. That intoxicated means 1 of 3 things, okay? The loss of physical faculties by reason of induction of alcohol or drugs or other combinations. Loss of mental faculties or a BAC, blood alcohol concentration, or code alcohol concentration of over 0.08. Okay, let's talk about each one of those. Okay. Number 1, mental faculties. You saw him on video. He was talking to the officer, answering questions, giving a story. Did he look like he had lost his mental ability? Oh, he knew exactly where he was, what he was doing, what he had done, where he was going. He did say he's tired. Okay. But mentally, he was perfectly fine. We all saw that. And there was no doubt that his mental faculties were not stored. Right? Next, we go to the physical faculties. All right. That's where these tests come in. Okay. The first one is the HG and eye test. The officer says he felt 4. You can't really see it. That's not something you can judge. You can with that. But you got to see the other 2 tests. What that one was the walk and turn. We had to start off like this. Say, and he said it a couple times. He was kind of doing that. That was one quote. You also heard it was video. When it's blowing there, you hear it on the officer's microphone. You see some of their clothes kind of blowing around. So that could be an explanation. And it's not like you're standing there like this, where you steady yourself, which is your normal base. And you gotta sit down like this like that. Sometimes it's kind of hard to do that. But then it takes his 9 steps. Kill the tug. You saw it. No someone, no wording off or things like that. 9 steps. Next clue was, there's really two clues in that test. The next one was the turn. And he's supposed to, like we said, at the end, to take some small steps and turn around and come back. That looks like it's in and looks like it's spin. Which, even ask the officer, that's much more difficult to do than small steps. But if you're intoxicated, you should fall over. You can't keep your balance. This balance is pretty good. You do that spin, no problem. Walk his 9 steps back, move to like that. No. And the next one is the one like stand away and stand like that for 30 seconds or whatever it was. Supposed to count from 1,000, 2, etc. And he said he's kind of wobbling, and you saw him kind of do something like that. Again, it was windy out there, right? He didn't fall over. He didn't refuse the test. He tried to do it the best he could out there with that wind blowing. Right? So the question becomes, did he lose his normal use of physical faculties? No. The officer said he wasn't starting his speech, which is normally an indication. He gets out of the car, walks back to the office, like stumble or wobble. Stands there, talks to the officer, perfectly fine. He hasn't lost his normal use of mental or physical faculties. Okay. But now we get to the big one. The thing that main reason we're here is the blood alcohol concentration. The citizen's going to argue to you, I'm sure she will, that it doesn't matter about those tests. What really matters is it's over 0.08. The results, they right here. Right there, you see it. 0.125. Black and white. But is it black and white? But yeah, it's written there black and white, but is there more to it? I'll point out a couple things to you. Right. Number one, the lab analyst, technician, whatever you want to call her, did say there's things that can cause false readings. Okay. I asked her, can there be false readings? Yeah. I asked her, does the instrument sometimes malfunction and perform wrong? Yeah. Okay. She says that it was working properly that day. Of course she said. Okay. Also, that was 6 years ago. This is not something that happened, 6 months ago, 6 years ago. So was it malfunctioning back then or not? We don't know. Okay, she says it wasn't, but you don't really know. You got to ask yourself, do you believe that the instruments that we don't know is working properly or not, or do you believe your own two eyes? What are you going to do? Did he appear to talk? Did he appear as somebody that's 0.125? Right? And he told you he'd been drinking. Yeah, I'm not going to deny that. But I asked the officer about that. Is it illegal to drink and then drive? No, it's not. You might have a drink and drive home. Or drive where you want to go. You don't have to go home. That's not illegal. Okay? Illegal is being intoxicated. And the only reason he even thought he was intoxicated was wine. Because he smelled like alcohol. Alcohol's come off his breath. He had to drink. No doubt about that. No denying it. He said on the video he had some beers between things, some went to Temptations, had some drinks. Okay. And again, also, some people may say, well, he was in some places he, was drinking where he shouldn't have been drinking or whatever. Some people might have some opinions about those places. You can't use those opinions. That doesn't really matter where it was. Right? But the question is, does his appearance, his actions, his speech, his walking, his balance, all the things that go to that, do they correspond to a 0.125 or not? What do you believe and what do you choose to believe? That's your decision to make. As a jury, you have the right to evaluate the evidence. And it even says, get the actual words of it. Number 2, you have the right to consider all the facts that are shown by the evidence and to draw natural, reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are. In evaluating evidence, you must totally disregard what you believe is, my opinion, in a judge, but any factual matter. You have the authority to say, look, I know it says 0.125, but I just don't think that it was a 0.125. maybe something's wrong with the machine, or the equipment, or the instrument, whatever you wanna call it. And I don't call it the technical name of the machine, because I've always looked at that stuff. But it's your decision to decide, is he intoxicated? Do I look at that video? Do I hear that video? And do I see and hear an intoxicated individual? Or do I see somebody who was taking his friends home because they were too intoxicated to drive? He said that. And do I see somebody who's been out probably much later than he wanted to be out, but is tired? That's the question you have to ask. And I think when you evaluate this and really look at it, then you come to the conclusion that Mr. Angel Cruz Bruno was not intoxicated at night. And you believe that, you fill out a part, whichever one of you is the person, sign that part says not guilty. Thank you.
Briefly, we're just gonna get something.
Okay.
You won't need to turn. Good afternoon, ladies and gentlemen. It's usually about this point in time where you're tired of hearing us talking, and I get it. I want to circle back to what we talked about in jury selection. I mentioned it in opening, and I'm going to mention it again. Public safety, deterrence, and accountability. And I'll get to this, deterrence and accountability, they'll go hand in hand. Public safety, I asked every single one of you why we do this in Jefferson County. And every single one of you raised your hands when you felt that we should hold people accountable for their actions. Now, you've heard from fellow jurors that talk to you about what has happened at the hands of intoxicated drivers. If we don't hold them accountable, people get hurt, people get injured, worse. Public safety, these are these same roads that you drove to get here, the same roads you drop your children off at school or pick them up. That is why we are here. Now, I'm not going to go into all these elements, now that Mr. West has gone over on. The only one really in question, he claims, is intoxication. Everything else has been stipulated to. So when you go back in the jury room and you deliberate, realistically, the only thing you're looking at is intoxication. And I'm going to submit to you right now that I have met my burden. And I'm going to start with the physical faculties here. He's claiming it's windy. He's claiming he had no slurred speech. I don't argue that. Remember back in jury selection when we talked about Lewis and Ogre? Ogre. High tolerance. No slurred speech. Could walk and talk. Champion drinker. Goes back to this. But his blood was greater than a 0.08. In fact, speaking in terms of this defendant right here, we have a blood alcohol concentration at 0.125. I submit to you that is above 0.08. Accountability and deterrence. Let's get to those two again. If we don't hold someone accountable, we're not deterring them for future wrongdoings. Do we really want to let someone walk away, get on the roadway in our county, and be intoxicated while driving, and something happened to you, your family, himself? We are very fortunate in this case that no one was hurt. But what if next time someone is? Accountability has no expiration date. I do not deny the fact that this case is from 2019. Accountability still should be had. Now, you're in the unique position where you can hold this man accountable. You have all the exhibits right here. You have State's Exhibit 1, the body worn camera from Officer Boudreaux. State's Exhibit 2, the unit dash camera from Officer Boudreaux. State's Exhibit 3, State's Exhibit 4, the actual results of the blood alcohol. You've heard it on the video. If there's something you're questioning, even testimony, if you want to hear it, you can ask for that very specifically. Go back to the video. Go back to the officer worn body camera where he's telling you he was very messed up earlier in the day. He says earlier in the day. I don't deny that. Do you hear him say he stopped at any point in time? I submit to you, he just tells you his burger goes on. He's laid off from work, why not? Let's have a good time. He goes to Twin Peaks, Four Tall Boys. After that, him and his buddies are having a good time. Goes to Temptations, 4 more beers. He admits this. He has been drinking all day. He leaves Temptations, it's 2:30 in the morning, give or take. He's trying to drop off a friend. We know within that time period, he's already had 8 beers. He gets stopped in Groves, obviously the Jefferson County comes into place here. And yes, his SFSTs, you know, you do see the stumbling, and if you have any doubt as to that, you can watch on the dash cam, which probably gives you a better view of that. Obviously, on his one leg stand, he is all over the place. You saw Officer Boudreaux show him how those tests are performed. Officer Boudreaux had no issue as to the wind. I submit to you when you watch that video, if you choose to, you're gonna see arms flailing. But let's go to the HGN, that first test that Officer Boudreaux performed. Yes, the defendant said he was sleepy. I imagine we're all tired at 4 in the morning. The HGN doesn't show signs of drowsiness or exhaustion. The officer told you it's showing signs of intoxication. Look at those clues on the HGN. Look at those clues on the walk and turn. This spin, whether you believe it or not, it is a clue of intoxication. But then definitely go to that one leg stand. You see it there, and I submit that to you. But I really, really want you to focus on the blood here. We talked about Ogre. He was just fine. We're looking at a BAC of 0.125. I submit to you after all these elements and you've seen them, I have met my burden. I want to reiterate that. Accountability has absolutely no expiration date. Whenever you go back to the jury room, you're going to deliberate. I ask that you take into consideration all the evidence that has been presented to you, ask for it. And on this verdict form, I ask that you find the defendant guilty. Thank you.
Well, ladies and gentlemen of the jury, at this time, the evidence, all the evidence in the court's charge and the closing arguments are before you. Before I hand the bailiff the charge to give to you, I need to inform you that one person on the jury is an alternate, and the alternate is not allowed to go into the jury room to deliberate. An alternate will stand by and be available to go into the jury room if something happens and one of the jurors cannot go forward. So at this time, the alternate in this case is Scott Hatcher. That's you? Okay. Mr. Hatcher. So, Mr. Hatcher, you can either stay in the courtroom or you can have a seat in the hall, whichever is convenient for you. And so, ladies and gentlemen of the jury, you will be, the charge will be left with you in the jury room. And once all the members of your jury are present and assembled in the jury room, the case is formally submitted to you and you may begin your deliberations. So at this time, we'd ask that you would please step down from the jury box and accompany the bailiff into the jury room, and we'll stand in recess until the jury has reached a verdict. We'll be in recess. Jefferson County Court at Law number 2 is back in session. The court is in session in cause number M 324-280, case of Styles, State of Texas versus Angel Luis Cruz Bruno. Mr. Cruz Bruno is present in court with his attorney. Attorney John West State is present with Assistant Criminal District Attorneys. Attorney Haley Simmons, Attorney Shane Hilton, and Attorney Andrew Hubel. The jury in this case earlier found that Mr. Cruz Bruno was guilty of the charge of DWI. The parties have come to an agreement regarding the punishment. State, is that correct?
That's correct, Your Honor.
And defense, is that correct?
That's correct, Your Honor.
Okay. Now Mr. Cruz Bruno, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. Mr. Cruz Bruno, I have before me a document that is titled Trial Court Certification of Defendant's Right of Appeal. You recognize this document? And at the bottom of this document, on the line that's titled Defendant, is that your signature? And at the top of this document, there are 2 boxes that's checked. The first box that's checked states that I don't think he has to do is check the
They might be just a second.
The second,
It's not
right.
a plea bargain, you're right. That's, I
right.
think we need to erase that first.
Here you go.
That's right. I
Yeah,
did
that's just
that.
not
That's,
yeah.
because it's not a plea bargain, it's just you waived your right of appeal.
Yeah.
Yeah, I think that's more accurate.
Okay.
now.
Now, Mr. Cruz Bruno, I have before me a document that is, again, this document is Trial Court Certification Defense Right of Appeal. You acknowledge that this is your signature on this document. At the top of this document, there's 1 box that's checked. The box that's checked states that you're waiving your right to an appeal in this case. Is that correct?
Correct.
I also have another document that is titled it's titled Misdemeanor Plea Admonishments. I'll just scratch out the word plea.
Sure. That makes sense.
So it's misdemeanor admonishments, and it states that in this document, that you're charged with driving while intoxicated, which is a Class B misdemeanor. The range of punishment for a Class B misdemeanor, DWI, is at least 72 hours, but not to exceed 180 days in jail, a fine not to exceed $2,000, or both such fine and confinement. Do you understand the range of punishment for a DWI? Okay. Now, on page 2 of this document, a set of initials, and I'll just put that. And it says here, AC, are those your initials? Yes. And it's next to a box that says guilty, and it was by the jury. Is that correct? And is this your signature on the line that's titled defendant? Yes. Okay. Now, and state, do we have a plea bargain agreement in this case?
The state and defense has agreed as to punishment following a jury trial verdict of guilty.
And what is the agreement?
The agreement is 90 days probated over 1 year, $500 fine, 24 hours community service, and just the DWI standard conditions of probation. The state and defense have agreed to no interlock as well.
What's the, let me see.
Should be.
Oh, it's
I'm
not,
retained.
oh, you retained,
Yeah.
okay. Let's see, what's the court cost?
192.
Okay, Mr. Cruz Bruno, the state is offering that you serve 90 days in Jefferson County Jail, but you would not have to serve any time in the Jefferson County Jail because you'll be placed on probation for 1 year. During the 1 year probationary period, you'll be required to pay a fine of $500 plus court costs of $392. You'll be required to pay a DWI conviction fee of $100. You'll be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, and a $15 reimbursement fee. Your total monthly installments, that is the total amount that you will be required to pay each month, is $173 a month. Will you be able to pay the $173 each month?
Yes, Joey.
You'll also be required to pay Jefferson County DWI education and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. You'll also be required to perform 24 hours of community service, attend and complete the DWI education class, have an alcohol assessment, adhere to the other standard terms and condition of DWI probation. And Mr. Cruz Bruno, do you understand the state's offer?
Yeah.
Do you think the state's offer in your case is fair and just? Do you accept the state's offer? Okay, Mr. Cruz Bruno, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. Cruz Bruno, would you please stand? What do I have? In front of the court coordinator, follow the directions of the bailiff. Hold on. Okay, and this will conclude the trial in this case. Mr. Angel Luis Cruz Bruno, cause number M324280. Mr. Cruz Bruno and Mr. West, you will be excused after you follow the directions of the bailiff. And state you are also excused.
Thank you.
Okay, everyone, please have a blessed day.